I think too, one of the things that we try to do for our clients is when they're wrong, tell them like, hey, we've definitely had clients, at least in my last 15 so years, where I'm like, this is a loser. Like, we got to figure out our job then as the attorney is how do we mitigate your damages? How do we reduce the amount that it's going to cost you to resolve this? Because there was a problem, did breach the contract, you did do the thing. So let's get you out of it for the least amount of money.
Right. And definitely, I think the benefit of having attorneys like us who do pretty much all business and civil litigation is that we have the experience and sort of the expertise to tell you we're prepared to have those difficult conversations and really help you assess things at the outset to determine the best course of action. Allison likes to get to point A and B in 2 seconds flat. And so we try to sort of circumvent the scenic route of litigation and get down to it. And if you tell me on day one, I want to take this to trial, it's more likely than not that that's going to change over the course of discussions, over the course of seeing documents, over the course of just sitting in the process of
sitting in a deposition. It's usually, if you have to sit through a deposition, that's a very quick tipping point. Mm-hmm. I also think the economics, right? Like this is where we like to talk with clients because I know what the average for our cases, and we get a lot of them resolved either through motion or through negotiations. But if you're taking a case to trial, I think, at a very bare minimum, it's 75 grand. Most of our cases that go to trial are going to exceed that. And it's not because we're billing excessively. It's the cost of litigation. You have a lot of time in those depositions. You have a lot of time responding to discovery. And some of that is because of how we get it. The clients that send us like the wonderful already labeled, it's all in the right direction, one PDF, that we spend a lot less time than when we get text messages of JPEGs. Every page is separate. Some are turned upside down. Those things kind of take time and add up, but there's a lot of that when we look into discovery.
Or the dreaded box of paper files.
Yeah, so the paper files get dropped off. But those type of things can drive it up, but just kind of all of those steps along the way. And prepping for a trial is just like a lot on both of us because we're invested. We want our client to win. We want to provide them the best possible case. And so, it's not just showing up to the day of, it's, months of prep, but really 2 weeks before is usually like super deep prep where we're like, do we know every document backwards and forwards? And do we know every question we're asking the witness, every hypothetical response we're getting from the opposition side that would throw a wrench in our case? And
I think a lot of people in the world, and maybe some of our clients, and hopefully we dispel this rumor, but I think a lot of people think that attorneys just sort of run up the meter, that veritable taxi cab meter. But it's really what we try to do is the time that we put in is all in service of preparation for whatever the next step is in litigation, whether it's a deposition or whether it is a trial. We try to be upfront with you about what that's going to look like. And that's also, frankly, part of those difficult decisions we have, because if you don't want to pay me, then maybe that's a time where we want to start talking about settlement. Or if, you're sick of hearing from me every couple of days on the phone, you want to get rid of the case, then maybe that's another time we talk about settlement. It really just depends. And I've found that different clients have a different threshold for litigation. And maybe it's the patience meter, maybe it's the pocketbook. It just depends. And some people are just dug in and they say, no, we're taking this to trial. I didn't do anything wrong. And as much as you and I love to get into a courtroom, that's when we have those conversations about
we just want to make sure they're going to be happy, because going into a courtroom, especially for a jury trial, you have no idea how the jury's going to decide. You could have what you think is the best possible case, but when you're putting it in front of 12 jurors who know nothing about it and are mad that they're missing work and getting paid $12 a day to sit there and the seats are uncomfortable and all of those things add into how's the jury going to decide. They didn't like that you didn't smile at them, right? Like legitimate things.
They didn't like that you wore a green blazer on Tuesday. I mean, it could be anything. With a jury trial, you really are at the mercy of whoever's sitting in those seats. And while attorneys go to great lengths to select the proper jurors through the jury selection process, at the end of the day, it comes down to how your case comes across to them, whether it's our presentation of the case, whether it's how the witnesses came across on the stand, whether it's something silly like they thought you had a bad attitude, or they didn't like what you were wearing, or maybe they're
Oh, I'm convinced I won a case because one of the jurors had like a medical appointment and no one struck her. And so that she was just irritated that she like had waited 6 months to get this medical appointment and now had to kick it out. And I think we won because she was like, that plaintiff wasted my time.
yeah.
And I'm like, that's fine. Like I was so happy to have her on the jury because I was like, please think that. Please sway the other 11 people.
It's interesting because sometimes you look at like an election and you think, how did these people get elected? And it's like, well, everyone gets the same vote. And just like that, everyone is eligible for the jury pool. So you really are at the mercy of a very diverse group of your peers who, like Allison said, might be mad because they're missing an appointment at work, or might be mad because they want to go on their kids' field trip. We try to make sure that our presentation is not only accurate and advocating for you, but also so it's as clear as possible, because we know that in a jury trial, we can't use legalese or words that we might use in a bench trial because a judge is listening to this kind of thing every day. But if your jury's made up of a teacher and a nurse and a realtor, then you have to realize you're in a different arena and you need to tailor it so that they understand and want to find your side of the case convincing and sympathetic.
Also, interesting.
Interesting. Yeah. Yeah. Because I think the biggest reality check that a juror gets is that this is nothing like TV.
Oh, how boring it is. I remember in law school, I went to an appellate uh, oral argument and it was on like some minute contract term. And I was like, I'm in law school and I find law interesting. And I went to that and I was like, oh, this is like the most boring. Like it was the equivalent of arguing where a comma goes. And I was like, I'm out. Like I have no.
Oh, yeah. And I mean, so often with civil cases, you're coming down to a contract term or
It's not sexy. Like that's the thing. Like
no,
civil litigation well, obviously we find it very interesting.
I
Um,
still wouldn't call it sexy.
no, no. And it is sometimes hard to get a jury to truly care, but that's on both sides, right? And so sometimes that plays to our benefit because the juror's just like, why you're wasting my time. All right. Well, I think this was a really good conversation, a high level overview of what takes place in litigation. And we should have prefaced this by saying we're talking about litigation at the municipal, common pleas, and federal court level. Small claims has a very different process. It's quicker, more streamlined, more accessible. But we'll have another video on small claims.